for just about a year for those who couldn't join us live during this session. So again, my name is Meg Garvin. I am the Executive Director of the National Crime Victim Law Institute, and we are incredibly excited to be partnering with all of you on making victims' rights meaningful, the role of advocates after Act 77 of 2022. This is going to be a really interactive training. We're going to be using the chat box a lot. And so we're going to start right now by having everyone please use the chat box to introduce yourself a little bit, if you wouldn't mind. So please use the chat box and introduce yourself. Tell us something about yourself. What is your Monday looking like? Anything that you can in the chat box, just so we know that your capacity to use the chat box, whether you're typing or doing it through some other mechanism, is working. We would really appreciate that. Okay, wonderful. It's all coming in. Terrific, terrific. As I already mentioned, some housekeeping matters. The training is being recorded. All of you are muted, but we, as you see, we are starting from the very beginning with you participating. We will have a number of polls happen throughout the day. And what we're going to ask you to do here in just a moment is scroll back up through the chat to see the community that has joined you, right? This is about making a difference by doing things together in community. And so even though we aren't physically together, we are together in community. So after you type in your introduction, please scroll through for a moment and look at everyone else. And I'm going to do the same thing here for just a moment. Oh, this is so exciting. People from all over the state. Wonderful. Okay, keep typing if you haven't gotten yours in. And what I want to do is now take a moment to introduce myself and our team just a little bit more, as well as our agency, the National Crime Victim Law Institute. So the National Crime Victim Law Institute, which is known as NCVLI, we work nationally to actively promote comprehensive and enforceable legal rights and access to knowledgeable attorneys. So I want to pause for a moment on comprehensive and enforceable legal rights, because really that's why we're joining you today. We have been working nationally to ensure not only is there a breadth of rights afforded by law, right, from notice to the right to be present and heard, to participate, to privacy, that breadth, right, that's the comprehensive part, but also enforceable. And what we mean by enforceable, you're going to learn a little bit more of today, but fundamentally enforceable means that there's an apostrophe on victims' rights, right? The victim owns a right and they get to ask for it themselves. So we have been working nationally to ensure there's this breadth, comprehensive rights, and that the survivor has a meaningful role to play by asking for them themselves in the system, and that our system has to respond to them. And that's what Act 77 really elevates state, is this enforceable part. And I say elevated, and our trainers today are going to explain why I said elevated and not created, right? And then access to knowledgeable attorneys. And we know this training is about advocates. And what we know is that you can't have an attorney help a survivor without an advocate also. That is a lesson NCVLI has learned over its 20 plus years of doing legal advocacy work for survivors across the country. We do our work in a crime victim centered way, meaning it's always about what does this survivor want to do right now, today, with this right. And we do it through education, legal advocacy, and resource sharing. Today is about education, but it's education to increase legal advocacy. And we're going to share some resources with you about how we can continue to help you as you do your advocacy work. So who is the we of today? Again, my name, Meg Garvin, she, her, my pronouns, and I'm the director here at the National Crime Victim Law Institute. And we have two of our legal team members here who are going to be doing the heavy lifting of the training today. And that is Rebecca Khalil and Terry Campos. And so with that, I'm going to turn it over to them.
All right, thank you, Meg. Before we get started, I'm going to have a little opportunity just to allow myself and Terry to say hi and introduce ourselves before we jump right into the material. So my name is Rebecca Khalil. I go by Becca, and I'm one of the legal team members at NCBLI, and I've been doing victims' rights work for the past 12 years exclusively, all around the country, including in Pennsylvania. So it's really fantastic to be able to see some of you, like actually see some of you on the screen, and to be able to interact with you during this training today. And Terry, do you want to take a minute to introduce yourself as well?
Sure. Thanks, Becca. So I'm Terry Campos, and I am also a member of the legal team here at NCBLI. I've worked with Meg and Becca for as long as Becca's been here, 12 years, and with Meg a little bit longer, about 14, 15 years. We love doing this work, training advocates, and I'm really excited about today.
Excellent. All right, so let's jump right in. We are going to jump right in with our first poll. So we're going to bring up the first poll. We see you've already shared so much along the side in the chat about where you're from, and there are 190 something people on the line right now. So to get sort of a broad sense of who's on the line without having to read 190 something chat messages, we have a quick poll that will come out asking you to select the category of the role that applies to you. And I'm not sure if I see it yet.
It's coming, sorry.
Okay, excellent. And your options that we have given you, we apologize if we have not captured your role accurately. We've given you the option of prosecution-based advocate, law enforcement-based advocate, another type of system-based advocate, a community-based advocate, a mental health professional, an attorney, or other. And especially if you've chosen the other option, please feel free to add that to the chat as well in case you have not already done that.
And I see the results are coming in. People are voting.
Oh, this is kind of fun. It gives real-time updates. This is very neat. All right, we'll give folks just another second to go ahead and fill out that poll if you haven't yet and you would like to. And then we will summarize what we're seeing, just so you know what we're seeing in case you can't see the chat on your end as well. All right, so it's looking like about 20% of you currently on the line with us are prosecution-based advocates, 2% law enforcement-based advocate, 20% of another system-based type of advocate, 37% community-based advocates, 3% mental health professionals, 3% attorneys, and 12% of other. And thank you. I'm seeing a few in the chat about some of the others that we've got here as well. Prevention education, victim compensation assistance. So this is great. And thank you for those of you who were unable to see the poll for adding it in the chat as well, since we do want to be able to capture that even if the technology is not playing nicely. So I'm thrilled to see so many people from so many different areas of victim advocacy from across the state joining us today. And I think we are going to cover topics that will apply to many people's work. It's a very broad-based sort of information. So some of the things that we talk about may not be things that you do directly in your role, but they will be things that other people, your complementary service providers, your referral partners, that they do in their work with victims as well. All right, I'm going to go ahead and move us forward. Moved us too far. So here's what we're going to do during today. By the end of today's session, so before this hour and a half is up, you'll be able to explain the similarities and differences between compliance with and enforcement of victims' rights. You'll be able to talk about what standing is and what it means for enforcement of rights. You'll be able to spot victims' rights at risk of violation and identify why rights assertion matters. And you'll know when to refer victims to victims' rights attorneys. And we're going to start with some of the basics. So we're going to start with what for many of you is probably going to be an incredibly broad review of what rights in Pennsylvania look like. But for some of you, this might be new information or different information than you deal with on a regular basis. So we are not going to go into depth about what Pennsylvania's victims' rights look like, but we are going to provide an overview of it, just to make sure that everybody is on the same page as we get started, regardless of what type of role you play in terms of victims' rights, and regardless of what type of role you play in your particular job. And when we talk about victims' rights, from a really basic perspective, we talk about these rights as being loosely or really generally grouped into 4 different categories. And those categories are rights that relate to protection, rights that relate to privacy, rights that relate to participation in the justice systems, and rights that relate to property. And those property rights are ones that you might think of in terms of like compensation or restitution. But the P goes much better with our graphics. So we took a little liberties with our categorization here. So there are definitely overlaps, right, between the different rights that exist and what category they might fall into. But this is one way to think about victims' rights and what function they serve for the survivors who are interacting with the justice system. And thinking about where these rights are in the law is also really important. So when we're thinking about victims' rights in Pennsylvania, we can find those rights in a number of different places. And Pennsylvania, before Act 77, has always had rights, right? Like that has not changed. What we're going to be talking about today has not changed victims' rights in Pennsylvania in a really like groundbreaking way. What it has done is changed the ease with which some practitioners may be able to help victims seek enforcement of some of those rights. So when we're looking at rights in Pennsylvania, we're going to look at a couple of different main places to find where those rights are in the law. And one place is Pennsylvania's Constitution, right? The strongest type of protection, legal protection that you can have under state law is going to be in the Constitution. The next place to look is to Pennsylvania's statutes, which is sort of the second strongest place to find rights. And then Pennsylvania's rules have rights as well. And when we look at Pennsylvania's Constitution, we know that there was a very recent movement recently to get rights that are specific to victims of crime put into Pennsylvania's Constitution. And there were some legal problems with that, and they're no longer in the Constitution. They were overruled by the Supreme Court. But those weren't the only rights in Pennsylvania's Constitution that apply to victims of crime. Rights that apply to everyone in Pennsylvania also apply to victims of crime. So we've included a few rights on the screen in front of you. So the ones that we're going to highlight for today's training are the inherent rights of mankind, including the right to protect one's reputation. That's a right that applies to everyone in Pennsylvania, regardless of whether you are a survivor or not. Security from unreasonable searches and seizures is another right that applies to everyone in Pennsylvania. We often think of that right in terms of criminal defendants, but it's not a right that's exclusive to criminal defendants. That right applies to everybody. Rights to open courts, remedies by due course of law, and the right and justice administered without sale, denial, or delay. All of these really broad rights that are in Pennsylvania's Constitution apply to victims of crime as well. And we took a moment to point these out and pause on them because sometimes it's easy to forget that when a person becomes a victim of crime, their other rights don't go away. Just because you have rights that are specific to survivors doesn't mean you somehow give up those broader rights that apply to everybody in all the contexts in Pennsylvania. So we're pausing on that now to not overlook Pennsylvania's Constitution because there are rights in there that are important for survivors as well. And then Pennsylvania's statutes. This is where a lot of meat of Pennsylvania's rights are found. And we've highlighted a couple. We are not going to go into depth of Pennsylvania statutes. That would be a whole hour-and-a-half training just itself, looking at all the rights in Pennsylvania, because you've got some really excellent and robust rights that apply to survivors. We're just going to highlight a few to give sort of a cross-section of some of the rights that exist. So the Crime Victims Act is a great place to start when you're looking for rights. It contains a whole list of different rights for survivors, and this includes some of the really important ones, including the right to information, the right to notice of significant justice system actions and proceedings, rights to not be excluded, rights to be accompanied by support persons, Rights to give prior comment on charges, pleas, sentencing, release, bail conditions, prior comment on all of these areas that impact survivors in a really concrete way. Rights to restitution, to compensation, to expeditious return of property, and notice of release. All these rights are in the Crime Victims Act. And there's a lot of nuance here that we're not going to go into, right? Some of these rights apply automatically to every survivor who comes into contact with the system. Some of these rights, especially in the context of juvenile justice, have to be activated. They have to be asked for before those rights come into play. Some rights apply to all survivors, some apply to a subset of survivors. So for example, they might only apply to victims of personal injury rights crimes. So there's a lot of nuance, even within this little list that we put on the screen, that we're not going to dive into now because our focus is elsewhere, but we want to provide sort of this overview. So in addition to the Crime Victims Act, even though there are a lot of rights for survivors that are included there, that's not the only place to look, right? If in an ideal world, if I were in charge of every state legislature, everybody would put all of the victims' rights really nicely grouped together in a way that makes the most sense for me. But sadly, I don't have that kind of power. So you have to look outside of any one particular provision and look in lots of different areas of the law to find where these rights live, because they apply to survivors. So we've included another one on this screen. There's rights to sexual assault testing and evidence collection is another right in Pennsylvania. And you can see when you're looking at the statutes numbers that we've included in the boxes, these are located in different areas of the law. This 18 at the beginning of this statute number says that this one is located in Title 18. This one's all the way over in Title 35. So you have to look in a completely different part of the law to find this statute than you would to find the crime.
Actually, I'm on a training. That's okay.
And those rights aren't the only rights either. There are a number of rights that are privacy-related rights. So some communications between victims and different individuals are given this really robust and extra strong set of privacy protections known as privilege, and we've included 3 of them here. So one of them is the sexual assault counselor privilege, the human trafficking caseworker privilege, and the domestic violence counselor advocate privilege. And again, these privileges themselves aren't located in the exact same part of the law either. 2 of them are found in Title 42 and one of them is over in Title 23. So you have to look at different places of the law to get a sense of what the rights look like and how they might apply to different survivors. So in addition to privacy-related rights, there are rights that are specific to certain victim populations. There's an act for the rights of child victims and witnesses that provides some additional protections to child victims. And there are rights of human trafficking victims that provide some additional explicit protections to victims of human trafficking. And there's the right to restitution. And there's more, right? We've included probably 5 slides of rights here. And there's a lot that we haven't included on the slide. There are whole separate statutory provisions addressing victims' right to give victim impact statements, either at sentencing or in connection with parole. There are rape shield provisions that provide some privacy protections for a victim's past sexual activity. There's laws that have to do with victims' rights in the context of universities, right? Title IX protections. So there are a lot of different areas to look at rights. And this is just a small glimpse of what exists in Pennsylvania with the purpose of conveying how robust your rights are, how broad they are in spectrum, and how many different ways they can apply to assist survivors in connection with the justice process.
And with that, we are going to take another poll. So Becca has just gone over the many laws in Pennsylvania that pertain to victims and survivors and their participation in the justice system. So a lot of rights, right? And she just touched on just an overview of them. We could go into much more detail, as she said. So that's great, right? Well, what is the significance of those laws? Let's pull up a poll and let's answer. Having rights on the books is enough to ensure that victims have a better experience in the justice systems. True or false? So you have all these rights. They're all in there. They're on the law. The Constitution, Becca said how powerful the Constitution was. We have all these rights, and that's great. So that is enough. True or false, to ensure that victims, that survivors have a better experience in the justice system. And I see people are voting. It's great. We got a lot coming in. Wonderful. So as you can see, and if you're having trouble seeing the chat, the poll, scroll up, because sometimes I think it gets moved down in the chat, and you should be able to just go up and then vote. So, right, I think we can conclude this poll in that right now 98% of you are saying false. And why is that? Why is merely passing the laws not enough? And go ahead and chat some thoughts in the chat box while we're discussing this. Why is it not enough to have all these really great laws, right? I mean, that's what we do. We pass laws so that people comport their behavior, right? Why is it not enough? Well, because not every participant in the system is going to follow the laws, right? And sometimes it's not about bad faith, right? They're not doing it because they don't want to comply with the laws. Many do not even know they exist or what they mean. In fact, victims' rights are so new, right? And victim participation in the system is so new that many times judges, prosecutors, defense attorneys, they don't know that these rights exist or what they mean, right? So they may read the law, right? They may read what's there and not know what it actually means or looks like in practice. And some actors, so some participants, judges, prosecutors, or defense attorneys, right? They might not feel like it's their job to ensure that the victim's rights are followed, right? So they might not be paying attention to those or what's going on with the victim or what's happening in the courtroom from the victim's perspective. So it's not enough just to have these laws on the books, right? So if Pennsylvania has these laws, but they're not followed, victims' experience will not change for the better. And this leads us to our next poll in the next slide. Why do enforceable rights matter to survivors? So this isn't a poll, it's a chat. So go ahead in the chat box, answer the question. Why is it important that we have enforceable rights? So now we're getting to that Act 77. Why is it important? And we're going to relate that back, how Act 77 provides the enforceability. But why is it important that we can enforce these rights? And let me go down and see what we've got coming up in the chat, because I see that we have some new messages coming in. So that everyone is protected, makes them feel heard and protected because the rights of offenders are enforceable. Okay, good. So you're seeing we got defendants have rights and they're enforceable, right? They can appeal, they can make challenges. And so if they're not followed, they can get a remedy. So they have legal standing, makes them feel heard. Right, so these are all really good ways of summarizing or restating why enforceability is important. And so let me just give you a metaphor and why it's important to have these rights more than just on the book. So say you go to a restaurant and you've been told it's great food, great service. You order a steak that's described as the choice cut, right? And the menu, it says 1 inch thick. The menu promises that it's the best in the city. Your order comes and the steak is paper thin. It's clearly not a choice cut, right? You're justifiably disappointed. You're like, hey, this isn't what I was promised. You call the waiter over and they come over and they say, hey, I was promised the best steak in the city. This falls way short. And the waiter apologizes and says, oh, I'm sorry you're disappointed, but this is how we do our steak. And you know what? I'll tell the manager to change the menu. And he just leaves. Are you happy? No, right? What if you had the option of the waiter apologizes and then says, let me get the manager. The manager comes over and you say, I didn't get the steak that was promised in the menu. The manager apologizes and provides you with the option of you can eat this steak and I'll comp your meal so you won't have to pay for it. Or you come back tomorrow night and we'll make sure we have a nice, thick, better steak for you that will live up to what we promised. But either way, we're going to change the menu so that other diners will know what steak they're going to be getting when they order, right? So in both situations, you didn't necessarily get the steak you were expecting, but in the second scenario, you're not as disappointed, right? You're not feeling like, hey, I was promised something and I don't get it. As in the first one, when you didn't have a remedy for the broken promise. And that's kind of the difference between having the standing, the explicit standing where you can come in and enforce those rights, right? You can say, hey, I was expecting this right, I didn't get it, and then you can do something about it. And so that you have a remedy. So when looking at the victim satisfaction in the criminal justice system, studies have shown that where there's going to be more victim satisfaction with the whole process when they have expansive rights. So when they have all these rights on the books, but they aren't actually afforded, right? Because that means, you know, they were promised something, their expectations are up, and then they don't get it, and there's nothing they can do about it. And so they feel worse. So, but in order to have those kind of expectations and stuff, they need to know what those promises are, right? So victims need to know what those rights are and what they can be asking for. So let's take another poll and see what you think. So here we're going to ask you, most victims can recite their rights just as easily as the defendant can recite theirs. True or false, right? Victims know their rights. You all work with victims, you work with survivors on a daily basis. Do they know their rights? True or false? And I see in the chat box again, if you don't see it, go on up, scroll up so you can get to it. Okay, yeah, 100% of you are saying false. And the sad thing is, right, the truth of the matter is, if I were to say to you, finish this sentence, you have the right to remain silent, anything you can say, you're likely able to fill that in, right? Anything you say can and will be used against you in a court of law. We all can recite defendants' rights, right? We all have an inkling, whether it's through TV, whether it's for movies, but how many of us can say the same for victims' rights? The rights are new, and they're not the focus of TV shows and movies. They're not commonplace, so it's very important that victims are informed of their rights in the first place. Because how can you ask for them, and how can you enforce them if you don't know? So that means that you, as advocates, play a key role in enforcing victims' rights. Education, information component often comes largely from advocates. So what are the other roles in the system? There are many different actors in the criminal justice system. A few are named on this slide. You can see community-based advocates, which I know we have a majority of you here. Prosecution-based advocates, again, a lot. There's prosecutors, right, involved, and there's victims' rights attorneys involved. So we all have different obligations and roles in helping the victims through the criminal justice system and providing different services. And each one has different obligations and roles. So when it comes to victims, and it's really important for each role, right, to work properly, and for each individual to stay in their lane and work on their role, not worrying about or taking over other people's roles. And one of the more really important reasons to know the different roles and the different obligations is privacy, right? Because when you as advocates have victims talking to you and telling you very personal, private things that have happened to them about the crime, and they may even divulge other things that are not about the crime, right? And so you want to know, if I tell this, what I'm being told, to someone else in the system, what is their role? What are their privacy obligations to this victim? I know my privacy obligation, but what are the other actors? And you may not be the right person to be talking to the victim about certain things, because you know that your obligation regarding privacy, etc., is not going to be what the victim needs or wants, that you wouldn't be the most protective. So you want to be able to find and know which actor in the system can provide the level of privacy that the victim might want. So let's look at this a bit more. True or false? Law enforcement-based victim advocates and prosecution-based victim advocates may be subject to Brady disclosure obligations. And for those of you who are unsure of what Brady is and Brady obligations, right, what that is a constitutional rule-based right that for defendants, that if the prosecution, a prosecutor and those who work with the prosecutors in their office, has any information about the defendant in the crime that is material and exculpatory, meaning it goes to show that the defendant maybe didn't commit the crime, the not guiltiness of the defendant, it has to be turned over to the defendant. So now the question is, do law enforcement-based advocates have Brady obligations? And let's see, can we launch that poll, true or false? Did we already we did launch it. Okay, I've got to scroll down here on my chat. And it looks like a majority were saying true, right? And that's accurate, right? Because law enforcement is seen to be under the umbrella of the prosecutor. So if you're a law enforcement victim advocate, you cannot promise a victim full confidentiality, privilege. You can't say, hey, anything you tell me, I will not tell anyone else. You may have to turn that over to the prosecutor, who would then have to turn it over to defense. So let's look at our next poll then on here. Community-based advocates may have privilege with victims. Now, what is privilege, right? Privilege is the strongest form of privacy protection that you can have. And in Pennsylvania, fortunately, it's very strong. Advocate privileges are considered absolute. And so if you have that privilege, you are not going to be forced to turn that information over. So community-based advocates may have privilege with victims. True or false? True. Yes. So 94% of you got it right. True. Well, and it kind of depends, right? Because what type of community-based advocate are you? But Pennsylvania does have a sexual assault and domestic violence counselor and human trafficking caseworker privileges. So you want to know within your role as an advocate, do you fall within one of these categories such that you have privilege? And because that's really significant, because that way a survivor can come to you and talk and tell you things that they may not be able to tell that law enforcement-based victim advocate if they want to keep it private. So why does this matter? These privacy-related differences can matter a lot to a particular survivor. In fact, there are great quotes in studies out there that show that if a victim doesn't have privacy in the participation of the criminal justice system, that no other remedy really matters. Like, that's key. It's really important. So it's important to know the differences and be able to provide referrals to others with higher levels of privacy protections when possible and when required by the victim. And again, not all victims are going to want the same thing. So we need to know what level of privacy, what level of confidentiality that victim needs and wants, and then make the appropriate referrals. And with that, we're going to jump into our next phase of the proceeding, and I'm going to turn it over to Becca.
All right, so now we are diving into the real meat of Act 77, and the reason we are here today is to talk about standing, which is not staring and standing on your feet and staring at a wall. It is the legal term standing. I love how lawyers, we take words that we use in everyday life and we make them mean something different. And then they're terms of art, right? They're words that have a specific meaning in a specific context, and standing is one of those words. So knowing victims' rights in Pennsylvania is crucial. Knowing your level of privacy protection and the level of privacy protection offered by others is crucial. Being able to make those referrals to different victim assistance folks is crucial. And understanding the legal concept of standing is also crucial, because standing, this idea of standing, which we're going to talk about, is the key to making sure that victims' rights are enforceable. So what is standing? In a nutshell, standing is what gets a victim into court to be heard by a judge and have their issues resolved. Standing is that legal hook that allows you to be able to go before a judge and say, "Judge, my rights are either being violated or they will be violated. I need help. Please do something about it." And if you have standing, the judge can do something about it. If you don't have standing, the judge can't. You can't be heard. You can't be helped. You won't be an active participant in that conversation. So standing, put sort of differently, you can think of standing as not only what gets you into court and gets you heard by a judge and you can get help from a judge, it's also something you can think of as a recognized legal interest in connection with that case. Because many of us may have interest in various legal proceedings that are happening. We may watch proceedings on the news. We may read about them in the media. We may be interested, but we wouldn't have a legal interest. In order to have that legal interest, you have to have something yourself at stake in that case. So you're not just interested, you have got skin in the game. You've got something on the line. I'm going to mix metaphors in any minute now, so I'm going to stop metaphoring. But the bottom line is you have rights and interests at issue in that case. You personally do. And that is the key that kind of gets that interest to rise to that level of the legal interest. And so the Supreme Court has described standing. This is a case from 1975. And the question of standing, according to the United States Supreme Court, when they explain it, is whether the person coming before the court is entitled to have the court decide the merits of the dispute or the particular issue. So do you have enough interest in this case that the court has to do something when you bring an issue to their attention? And what does this mean in practice for victims? In practice, standing is what gets that victim into that criminal case in court to say, Judge, you've got help. Something is either going sideways in a way that's going to harm me, or something was done wrong in a way that has caused me harm, and you need to fix it. So standing is that ability to ask the court to intervene to protect victims' rights. And why is this important? Because without standing, you can't go into court, and you can't get the judge to help, and you can't get those remedies that you're looking for. And like Terry mentioned before, giving folks rights without remedies, without the ability to seek enforcement of them, is giving them a pretty piece of paper. It's not giving them a meaningful opportunity to interact with the justice system, which is what the law gives to victims. That's what these rights are meant to do. And standing is there to make sure that in this moment of enforceability, victims have the opportunity to seek enforcement of their rights when necessary, to make sure that they've got teeth, to make sure you're not getting the flimsy, overcharred, horrible piece of steak instead of your nice 1-inch thick juicy rights that you're entitled to. We've given victims juicy rights. They deserve juicy rights, and judges are the ones who can help make this happen when things are going astray. So let's take a little bit of a closer look at standing. And this slide shows you standing sort of before and after Act 77. So victims in Pennsylvania have always had standing. The question is, how easy was it to assert standing, and how easy was it to point to where in the law that standing lived? So before Act 77, standing lived in the law in case law. So you'd have to search the cases to figure out what judges have said about standing and what it takes to prove standing, and then you'd have to argue that your victim meets that definition of standing. It was very doable, and it's a lot harder than it is now, because now Act 77 gives you standing explicitly in the law. You don't have to go read cases. You have to find one statute, and there it is, in black and white, real easy. A victim or the Commonwealth, upon the request of the victim, shall have legal standing to assert and enforce a right enumerated in this act or in any other right afforded to the victim by law in a trial or appellate court or before an official body with jurisdiction over the victim's case. It is very easy now to point to where standing lives in Pennsylvania's law, which will make it easier when you need to go into court and you need the judge to listen to you, to say, here it is, judge, and why you have to listen to me to make sure this victim is getting their full rights afforded as they should be. One other thing to keep in mind when it comes to standing is that standing is fact specific. The question you're always asking when it comes to standing is, does this victim have the right at this moment to do whatever the thing is you need to do? So it's not enough to be able to say, here's Act 77, we have standing. You always have to look a little bit farther and see what right is at issue, and is this the right time to be asserting that right? So for example, victims have the right to speak at sentencing, to be heard at sentencing and give their impact statement, right? But does that give the victim the right to stand up in the middle of trial and talk about sentencing? Yeah, not really. No, it's not the right time, right? That right doesn't come into play yet. But if a victim wants to give their impact statement and the judge is finishing up sentencing and isn't letting them speak, is that a time when the victim can now say, I have this right now. I need you to let me exercise it, and you need to make the space for that to happen. Yeah, that's what standing is designed to do, to make sure that at the right moment, a victim can go into court and take that action to make sure that their rights are not lost or diluted into the nasty, like thin, overcooked piece of steak rights. So question for you in the chat, who can assert victims' rights? Who has standing to help victims do this? Go ahead and add in the chat. You don't have to know the answer yet, but you can give it a guess. Who might have standing to go into court to help a victim assert or seek enforcement of their rights? All right, we've got some good stuff coming in. So in Act 77, it was very explicit about who had standing to do this, right? We've got 3 folks who have standing to go into court and ask the judge for something. We've got the victim on their own can do this. The Commonwealth, at the request of the victim, can help a victim do this. And the victim can always have their own attorney to help assert and seek enforcement of their rights. So when we're thinking of standing and who goes into court and asks the judge for help on behalf of a victim can either do it on their own, they can ask the prosecutor to do it for them and help them, or they can have their own attorney do it on their behalf. So that's who's got standing in Pennsylvania. I'm going to turn it back over to Terry to talk a little bit about why this is important.
Oops. Thanks, Becca. Just trying to get myself oriented here. So as we heard, victims in Pennsylvania, right, we have these rights. And we talked about how these rights in the law books are merely words on paper. Becca said, you could make a promise and without enforcement, they're just going to get this really pretty paper with the right on it. And so meaning only comes when people ask for their rights, when courts enforce them, and when systems begin to routinely comply with them. So you have 3 components, right? We have people asking, so survivors asking for their rights, courts enforcing those rights, and then the system complying with those rights. And so we're going to talk a little bit about what that means when we're talking about compliance and enforcement, because we want to make sure that you have that understanding. And before we go into my discussion on compliance and enforcement, we're going to watch a little video about what the difference between compliance and enforcement means. And then we'll talk a little bit more about it after when we come back.
Victims' rights are designed to provide meaningful opportunities for victims to exercise choice and to have a voice in the criminal justice process. Depending on how a jurisdiction has structured its rights, many victims' rights do not require victims or others to affirmatively ask for their rights. These rights should happen automatically. For example, in many jurisdictions, victims have a right to notice of certain court proceedings, such as sentencing in a criminal case. And the victim has a right to automatically receive this notice, even if they don't specifically tell anyone that they want to be notified of the sentencing hearing. When these automatic rights are at issue, a victim may still have to formally assert them to a court if they've been violated or are at risk of being violated. In many jurisdictions, some rights may require that the victim take certain actions in order to activate their rights. Often, these rights are phrased as rights that are guaranteed to victims upon request. This means that each victim needs to be told that they need to request these rights so they can make their own choice whether to request the right. Some jurisdictions provide forms that survivors can use to request their rights, but specific forms aren't the only way of asking for rights. Requesting rights can also look like asking the prosecutor, law enforcement, or other system actors for rights. Central to ensuring that victims' rights are meaningful are 3 distinct yet related legal concepts: rights compliance, and rights assertion and enforcement. Rights compliance happens when the system is working to honor and respect all of victims' rights. Compliance means that the rights are working as they should. For example, victims are being notified of proceedings, having their voices heard, and receiving restitution. Compliance is generally about the system having processes in place to ensure that victims know and understand that they have rights, know how to request them, and that the requests are being properly documented, and that rights are actually being afforded and victims are benefiting from them. An additional aspect of compliance is that the system is monitoring and improving itself. If something goes wrong, those responsible for it will identify the problem and improve policies and procedures to ensure that in the future, the system works more smoothly and affords victims' rights as effectively and comprehensively as it should. When rights compliance happens, everyone benefits because the system is working to protect and afford victims' rights to every victim in every case. Rights assertion is the formal act of asking a court or another court-like adjudicative body to enforce victims' rights. Victims can formally assert their rights on their own or with the help of their own victims' rights attorney, and at times through a prosecutor. Often, rights assertion comes after a victim has asked for their rights through another avenue. For example, A victim might ask for their right to confer with the prosecution by telling the prosecutor that they want to talk about the charges or about potential plea agreements. If a prosecutor will not confer or will not meaningfully confer with them, then the victim could formally assert their rights before a court, asking the court to make the prosecutor confer with them so that they can meaningfully exercise that right. Victims' rights enforcement often goes hand in hand with the act of formally asserting rights, when a survivor needs to involve the court system to protect their rights. When a victim, or their attorney, or upon request, the prosecutor, has asserted a victim's rights, it is the court or another adjudicative body that enforces the right. The assertion and the request for enforcement of rights can happen in a variety of ways, including through different motions and other legal tools that ask the court to issue orders to enforce victims' rights when they are in danger of being violated, or to issue orders to enforce the right by remedying violations after they occur. The dual role of enforcement, preventing violations of victims' rights from happening and remedying them if they do, can be crucial because it does not rely on the system itself to do what needs to be done. Enforcement involves courts, whose job it is to ensure that rights are protected, to make determinations about victims' rights, and to issue the orders that are necessary to make sure that this particular victim's right is protected in this case and at this moment. Although enforcement is initiated on a case-by-case basis, enforcement also benefits future victims, as court orders and decisions help create legal precedent that provides guidance for future cases as well. NCVLI has created a number of online resources to assist victims, victim advocates, and victims' rights attorneys with understanding victims' rights and that touch on rights compliance, assertion, and enforcement. Additional publications, videos, and other helpful resources can be found on NCVLI's website.
So from that video, we can see that compliance and enforcement are both important for victim satisfaction of the system, right? So if we think back to the restaurant metaphor, we want to make sure that every diner is happy with their food, which means that we want to make sure that the menu is accurate, right? We want to make sure that the restaurant is providing the food that they advertise. So that would be compliance, right? So going forward, after you complained about your food, the restaurant says, oh, we need to make some changes and we're going to make sure that everyone gets what is promised in the menu. Whereas enforcement goes one step further, and that diner right then, so that survivor right then can say to the manager, I want you to make it better for me. Not just everybody else that's going to be coming in, not every future survivor, but me. And so enforcement allows that survivor to get their remedy as well. So they get to have the food corrected, not just everybody else in the restaurant. So both are important, compliance and enforcement, for satisfaction with the criminal justice system. And I saw that there's a lot of questions in chat regarding victims' rights attorneys, and we're going to get to that. And there was also another question about victims' rights applying to parents of minor victims. And so we'll touch a little bit later on that, but we'll come back. But if we don't answer your questions throughout the next few slides, which I think we're going to, we will come back and make sure that we answer those. So don't worry about that, but keep those questions coming. Those are great. And with that, I'm going to turn it back over for Becca for a little pop quiz.
All right, so here's your pop quiz. And I love those questions because it shows that you're thinking about standing. When we put up that slide, it said who has standing. We have the victim, we have the victim's attorney, we have the Commonwealth at request to the victim. Some of those questions focusing on what about parents of children? Are they victims? What about me in this case? The question is always going to be who falls within the definition of victim. So you're going to look at the right, you're going to look at the definition of victim and see who falls within it. So when you're looking, for example, at the Crime Victims Act and you're looking at definition of victim, you can see it's the person who is directly harmed, and it's also the parent of a child victim who is harmed. So you're going to look at whatever the right is, take a look at that definition, and you're going to see who falls within the victim, because it may not be just one person. The definition of victim may be broader, and at different points and at different rights in the case, a definition of victim may encompass different individuals. Because, for example, when you look at restitution, the definition of victim for restitution is often broader than the definition of victim for other rights, like maybe the right to be heard in connection with a parole hearing. So there's going to be different definitions of rights that apply, which is why it's so fact specific, right? You have to look at the facts of that case, say, is this person a victim for this right? And is this moment when we go in and ask a court to help fix it and make it better for them right now? So I'm going to switch screens just so I can move this around. We've got a little pop quiz. And I've got a few boxes on the screen here of different moments that can occur. And I'm going to ask you to use the chat to tell me whether this feels more like a compliance moment, right? Like the system making itself better to correct any errors that have occurred, or if it feels more like an enforcement moment where the victim or the prosecutor or the victim's attorney needs to ask a court to get involved to make things right. So the first example, we'll just start with this one. So Pennsylvania Savin system successfully provided a survivor with notice of a convicted person's transfer to a different facility. Would this be more of an example of compliance or more of an example of enforcement? Great, I'm seeing in the chat, compliance, compliance, compliance. Yes, this is the system doing what the system ought to do and doing it well. So it isn't even a compliance moment where it needs to fix anything. This is the system working properly so that these victims have their rights respected. All right, we're going to go to the second example. A victim's attorney files a motion in court opposing a subpoena for privileged mental health records and asking the judge to quash the subpoena. And quashing the subpoena just means telling the person seeking the records that they can't have them. It means saying no. All right, in the chat, enforcement, yes, right? Because here we've got a situation where the victim has these rights. They've got these privileged communications. They don't want anybody else to access them. And they're asking the court to make sure that that happens, to make sure those rights are protected and that their private records don't get turned over to anybody else. So that's a great example of enforcement and an example of when victims often need the assistance of an attorney in order to do this, because even quash, like who knows what the word quash means? Like all I may know as a survivor is that I've got information I don't want anyone else to see, and I thought it was supposed to be private, and so I don't want anyone else to see it. But that's when the attorneys come in handy, because they know things like quash and what motion to file and the legal tools that are available to help make sure that that enforcement can assist that survivor. All right, let's look at another example. We've got law enforcement gives victim a brochure with information about their rights. Yep, I'm seeing it in the chat. Compliance. Law enforcement is providing victims with the information that they need and making sure that that right to information is fulfilled. So that's a great example of compliance. Here's another one. Let's do this one on the bottom. A prosecution-based victim advocate realizes when checking their records that they failed to record whether it's safe to leave a voicemail at the number that was provided by the victim. Following their policy, they reach out to the victim to seek clarification. Is that compliance or enforcement? Yeah, compliance. Great. So absolutely, here we've got a spot where the system goofed a little bit, right? Some information that was supposed to have been taken down wasn't taken down. But fortunately, there's already a process in place to make sure that when human error happens, because human error will happen, that there's a way to fix it. And the way to fix it is a way that doesn't put additional burden or harm or risk on the part of the survivor. It has the system taking steps, in this case, through the system-based advocate, to make sure that that victim, when they receive phone calls from their office, only receives them in a way that is safe for them to do that. All right, here, let's do this example. The prosecutor requests restitution in a really small amount, which does not include the victim's significant medical expenses, and the victim asks the court to include those expenses in the restitution order, which it does. Great, enforcement, right? This is a good example of enforcement. We've got a moment here in that case where the victim needs to ask the court for something directly. And we had a moment here where there was potential for something else to have happened, right? There was conversation between the victim and the prosecutor, and the victim wanted their medical expenses included in restitution, and for whatever reason, the prosecutor did not ask for those. So the victim, on their own behalf, went to the court and said, please make it right. I have a right to restitution for these expenses. The prosecutor isn't asking for them, but I have this right, and I'm asking for them. And in this case, we gave you the facts that the court actually does order restitution for those, but regardless of the outcome, even if the court had said no, those were not eligible expenses for restitution, for some reason you don't get it, even if the outcome isn't necessarily what the survivor wants, this is still an example of enforcement. You're still asking the court to step in and make something right for you. Then final example. So the prosecutor, at the victim's request, asked that the defendant submit to electronic monitoring as a condition of pretrial release. The court includes this condition. Exactly, we've got enforcement here. Here we've got the prosecutor with standing to help the victim assert their rights, asking for a specific condition of release to help keep the victim safe. And they ask that of the court. And the reason they can ask that of the court, right, on behalf of the victim is because they have standing to do that. And so you've got all these examples of enforcement, and all of these involve the judges or the courts doing something to help protect a victim's rights. And we've got all of these examples of compliance, which involve the system doing something to help protect the victim's rights without the need for judges to get involved and force them to do it. So both of these work in tandem with each other. Compliance and enforcement go hand in hand. Sometimes compliance on its own gets the victim, even in this case, exactly what they need in order for their rights to be afforded. Sometimes compliance on its own isn't enough. And then you need to go into court and seek enforcement of those rights.
All right. Well, we have provided you with a lot of information. You've heard about the laws, which you already knew, and we talked about standing and enforcement and compliance. And so now we're going to jump to the part of the training where we're going to put it into practice, because whenever we try to apply certain knowledge, that's when we learn like, oh, I didn't really understand it, or, oh, I have this question. And so we really want to use this time to dig in and really work with the idea of standing and enforcement and compliance, and see if you have any questions. And if you do, please put them in chat. We'll answer them as they come up if they're relevant. If not, we might save them to the end, but we are monitoring that, so we will get them. But really, also, there's no right or wrong. We do not want to put you on the spot and make you feel like you're getting a wrong answer. This is for you to really dig in and practice and see what it is that you might have questions about or want to know more about. So we're going to use some case scenarios and kind of work through it. So our first scenario that we're going to work through is about Alex and Jerry, and they're kind of going throughout the various scenarios that we're going to put forward, so they stay consistent. Alex recently started a new position as a prosecution-based advocate who works primarily with victims of sexual assault and domestic violence. Once a case is referred for prosecution, Alex reaches out to the victims to offer them support and information about their rights in connection with criminal proceedings. Jerry went to the hospital after experiencing a sexual assault at an on-campus party. Jerry doesn't remember getting anything from the officer who responded and wants to know more about their rights and also about the felony charges that have been filed. Alex knows from the case file that the defense attorney has already approached the prosecutor about a potential plea to a misdemeanor. Okay, so now let's put on our thinking hats. What rights of Jerry's are potentially at issue at this point in the case? So just throw in some ideas. What do you see here that's potentially problematic? What are some issues that might be coming up? Prior comment. Awesome, for sure, right? Because you want to have prior comment about the reduction or dropping of charges, right? Being able to communicate with the prosecutor ahead of time. Awesome. Right to be informed, right? Like you didn't get anything from the law enforcement. Notification, right? Appearance at court. Prior comment, right to information. Awesome, you guys, right? This is great. But what we want to be thinking about too, right? You've got all these things that happened and that you're acknowledging in chat. But what happens if it is reduced to a misdemeanor, right? We want to be thinking about the follow-along rights, such as restitution and giving a victim impact statement at sentencing, which could potentially be implicated if the misdemeanor ends up being a crime where Jerry might not qualify as a victim anymore, right? So what if it's something related to furnishing alcohol to another or unrelated minors at an on-campus party? What if there's something that the crime that he pleads guilty to removes the status as victim, right? And so you lose all these other rights as well. So you don't want to forget about that when we're thinking about it. In terms of compliance, what might Alex be able to do to make sure Jerry's rights are afforded? So we're thinking about compliance now. What is the out of court that Alex could do that might help to afford some of those rights? And one of them we've already talked about. And go ahead and put in chat. What is an advocate? What might you want to do? Give him a brochure of rights. Great. Thank you, Greg. Talking about, right? Sitting down, going over those rights with Alex or with Jerry, right? Sitting down and reviewing all their rights. So they didn't get a brochure, but now you're going to go over them with them. Approach the prosecutor. If they don't comply, approach the courts. So share rights to info. So Jessica's saying when approach the prosecutor, you're saying go talk, have a conversation with the prosecutor, right? Yeah, you want to see that that's echoed again. Rights notification, right? Provide those rights. And then also maybe checking in advance to see if anyone spoke with Jerry before Alex took over the case, because looks like Alex came in a little bit later. And so like, right, you don't know what's gone on before that, before you came in and started working with Jerry. Did they talk about prior comment or plea a deal already? Like maybe that already happened. Assisting Jerry, like reminding Jerry, the prosecutor, like we talked about this, right? Like the talking to the prosecutor, reminding the prosecutor, hey, Jerry has these rights, and offering to assist the prosecutor. Is there anything I can do to help out with this, to make sure, you know, arranging a meeting with you two. Working with Jerry so they understand their rights and in ways in which they might be able to offer prior comment about any potential plea. So sitting down and saying like, here's how we can maybe work out a way for you to talk to the prosecutor, and what works for you so that you can actually get in there and have that prior comment opportunity. In terms of enforcement, what might happen if Jerry is not given the opportunity to provide prior comment on the plea agreement? What might enforcement options look like here? And Abby, I see that we've got some really great things going on up there. Ask for deferred sentencing if victim can't make it to court. Let's see. Victim compensation for medical expense. So that's another way that you could be helping, right? Compliance, right? What they want to see happen with the defendant. So again, like finding out what they want to see happen and working to make sure we can discuss with the prosecutor. We have a question. What if the prosecutor does not agree to have these conversations? What do you think? What do you think would happen? What should happen if there is no communication, that prior comment doesn't happen? What should you be doing at that point as an advocate? Oh, and I see Ingrid saying hire a victim attorney or referral to a victim's rights attorney, right? Reaching out so that that role of enforcing those rights, because the prosecutor's not willing to do it, then they have a victim's rights attorney to come in and help them enforce that rights. So that would be one of the enforcement options that might look like, right? Referral to a victim's rights attorney. There could be that motion to delay the hearing, which is what was already offered in, which I thought deferred sentencing, that was great, right? Giving Jerry time to come in and exercise their right to prior comment, having those conversations with the prosecutor, and filing a motion. Like a victim's rights attorney could come in and file a motion to reject the plea based on violations of Jerry's rights for prior comment. And then also providing a victim impact statement to the court. So Jerry would comment on the sentence based on the plea at sentencing. You know, I didn't agree to this, I didn't want it, being able to have their voice heard in a victim impact statement. So many victims, the thing that you want to, and I see we have a hand raised. Can you put that in chat, your question? Who funds the victim's rights attorney? Right, well, unfortunately, the courts are not paying like they would for a defense attorney, right? They don't have public defenders, they don't have public victims' rights attorneys, but we do have pro bono victims' rights attorneys around the country who are doing this work for free. And NCBLI has a pro bono pool. We have a group of attorneys that we work with that we can make referrals, and we'll get back to that. So that's a question we're gonna come back to for sure. But there are also civil attorneys who have a civil practice that helps them kind of balance out when they do victims' rights work for free, that they may have it tied to a civil case, so therefore they get payment that way. So there's a lot of different ways in which they can be funded, but we do really try hard to get the pro bono attorneys working. And that brings us perfectly into our next slide, which is the role of the victim's rights attorney. And as you can see from that last, and I can see those questions coming in, you know, as Becca's putting in the chat, one day the goal is that every victim, right, would have access to a free, knowledgeable attorney in every case to help with their victims' rights. And if you remember way back in the beginning when Meg did the introduction, she talked about how one of our goals at NCBLI is providing knowledgeable attorneys to assist victims. And so that's what we work towards. We work towards partnering victims with attorneys who can help them in cases with a live issue. And the role is really crucial because not every victim, right, is going to understand their rights or how to go ahead and assert those rights or enforce those rights. And there's going to be times like what we just seen in chat where the prosecutor is going to disagree with the victim's options, right? Or they're not going to proceed in a way that the victim would prefer. And the difference is, right, a prosecutor represents the state of Pennsylvania. The prosecutor does not represent the victim. So the prosecutor is able to say, no, I'm not going to do that, or this is how we're going to proceed with the case because that's how I feel it's best interest of the state. Whereas a victim's rights attorney is representing the victim and the victim only. And so they will assert the rights of the victim and the interests of the victim and advocate for what the victim wants, which may be in opposition to what the prosecutor wants. And victims' rights attorneys have access to legal tools, right? They know how to file motions. They know how to explain the rights to victims and let them give victims agency, right? Because that's really the key here, right? When are we most satisfied in life? When we have options and we're allowed to choose on our own behalf what we want to do. And that's what victims' rights attorneys can help, right? What do you want in this case? Here are your rights. Let me explain what they mean. What do you want to do? And then accessing and going forth with a legal tool. So filing motions to make that happen, and various things like that, right? And they can help accomplish those goals. They can stand up in the court, which a victim is very not going to feel comfortable doing, right? And may not know when they can do it. So they're able to come into court and do that. And I have a question here. Can a guardian ad litem help the victim if it's a child? Yes, but remember, guardian ad litem is different than a victim's rights attorney. A guardian ad litem acts on the best interest of the child. Now, a child who is, say, 14 years old may be able to say, I want this. And the guardian ad litem can say, that's not in your best interest. This is in your best interest. So I'm going to advocate for this over here. A victim's rights attorney will listen to that child and say, that's what you want. Okay, that's what we're going to do. They don't do the best interest analysis. They work to advise their client and then work on behalf of what their client wants. So there's a big difference between a guardian ad litem and a victim's rights attorney. Sometimes they work very well in conjunction and they have the same goal, but sometimes there can be some differences. And not every guardian ad litem may be an attorney. And so that we're going to move along so we have time to get through some more of these good issues, but I love these questions that are coming in because it shows that you all are really thinking.
And we're seeing some great questions in the chat that are really specific to certain right scenarios. Like, does this apply in this situation? What's the contours of this right? This training won't be able to get into those issues in depth, but if you head over to NCBLI's website, we have a form where you can request technical assistance, which is when we'd be able to dig into some of those questions and get back to you with the legal information about how rights look in that particular type of way. So I do want to acknowledge that we see those questions and that we won't be able to cover them in this particular training, but we do have a form available so you can still submit that question and we'd be able to look into it, just not right this moment. All right, so our scenario is continuing. We've got Alex has spent some time working with Jerry and the case ends up proceeding to trial on 2 different felony charges. Jerry's also working with a community-based advocate at a local sexual assault advocacy organization in their local community and has interfaced with an advocate at their university and is also seeing a therapist. 3 weeks before trial is scheduled to begin, Alex gets a subpoena from the defendant's attorney seeking access to all the information and records relating to Alex's interactions with Jerry. The community-based advocate, the campus-based advocate, and the therapist also received similar subpoenas. When Jerry learns of these subpoenas, Jerry is upset. I think upset is probably an understatement of how Jerry is feeling in that moment, and calls Alex asking what they should do. Now, we've given you a bit of a trick in this question, right? We've talked a little bit about how victims' attorneys can help move to quash subpoenas to protect those private records. So this is a great moment and a great time to refer to a victim's rights attorney, or maybe the prosecutor wants to help get involved and help Jerry protect the privacy of some of those records, especially since some of the records being sought are the records of Alex, the prosecutor's own advocate in their office. So this may be a situation where the prosecutor may want to help the victim seek enforcement of their rights, right? But we snuck in there that should. Alex gets a question from Jerry asking what should they do? And we know that is not the role of an advocate, right? Advocates provide information and options so that a victim can choose what they want to do, but advocates don't tell a victim what to do. Attorneys, on the other hand, we enjoy telling people what to do all the time in conversation, of course. So I joke, but that should moment when a victim really wants somebody to just say, what should I do? That is a great time to connect a victim with an attorney, because that should is what gets you over the line from being able to provide information and options about victims' rights in connection with the case into providing maybe legal advice, which is where you don't want to go as an advocate. That's why attorneys can come in and have that conversation, that if a client needs further guidance and more than you and your role can provide, that's where victims' rights attorneys can really come in. And who potentially could help Jerry assert or seek enforcement of their rights in this case? Jerry could, in theory, do it on their own if Jerry feels comfortable doing that, which most victims probably do not when it comes to their private records being subpoenaed. The prosecutor could, on request, help Jerry out and do that. And Jerry could get their own attorney to help them do that as well. So there's a lot of options here for Jerry. And one of the reasons why we're pushing so hard on this issue of the attorney is because attorneys play a really important role. We've got a quote on the screen from a United States Supreme Court case from 1932. And this was something that was said in the context of a criminal defendant and their access to an attorney. So this isn't a victim context, but it is the attorney context. And the Supreme Court observed that the right to be heard, that was at issue in this case, would in many cases be of little avail if it did not comprehend the right to be heard by counsel with an attorney. Even the intelligent and educated layman has small and sometimes no skill in the science of law. He's unfamiliar with the rules of evidence. He lacks both the skill and the knowledge to adequately prepare his defense, even if he might have a perfect one. He requires the guiding hand of counsel at every step of the proceedings. So the Supreme Court has recognized how little a normal human being is prepared to be their own lawyer, to play lawyer. There's a reason people go to school for a really long time to do this, because it can be really hard and it can be really complicated, and it can be, more than anything else, really intimidating to go into court and ask for help. Criminal defendants aren't prepared to do this on their own. Victims aren't prepared to do this on their own. And sort of the really interesting sort of confluence of information is that we've had defendants' rights, and they're talking about defendants' rights in this case. They've been part of the federal Constitution since forever, shortly after the founding. We've got the Bill of Rights that lays out all these rights for criminal defendants. And it wasn't until almost 200 years after the Bill of Rights that the Supreme Court started to really flesh out what those rights mean, what they look like in practice. And that didn't start happening until the 1960s and 1970s, when there were all these cases exploding about what defendants' rights means. And why did that happen? In the early 1960s, criminal defendants got the right to an attorney in state cases. It doesn't need to take 200 years for victims' rights to start getting fleshed out by the court and say what they mean and have it litigated in court. This can be done sooner than that, because courts interact with attorneys make arguments, and case law starts coming down and shaping the contours of the law and informing future cases.
Great. So there are, when we look on, sorry, I'm just trying to answer in chat and then I got a little confused here. So we're going to focus on some concrete examples of litigation and what it looks like maybe to have common motions or pleadings to protect victims' rights. So let's look at some examples, right? Basically, there are two main types of legal remedies when we're talking about enforcement. When you go before a court, there's the stop. I'm just waiting for the PowerPoint to catch up with me here. There's the stop. So you go into court, whether it's the prosecutor, the victim, or the victim's attorney, go into court and file a motion that says, court, my rights are being violated. I want you to stop what you're doing and stop violating my rights. And the other option, which is often a corollary with this stop, is the do-over. You need to do it over. You did that wrong. That hearing you had, you violated my rights. You need to do that hearing again. You took that plea without having my opportunity to have prior comment. You need to do that plea over again so that I can meet with the prosecutor and have that conversation and talk with them about what I want. So stop and do over. So whenever you're thinking about enforcement, you should be thinking about, all right, are we telling the court to stop? Are we asking for the court to do something over? That would be your main legal remedies for enforcement.
And we'll sort of give you a quiz on this one as well. So Alex, in our previous example, has referred Jerry to that victim's rights attorney who was able to assist with the subpoenas that were issued for their private information. Jerry and their attorneys end up deciding to file a motion to seek protection. They file this motion to quash the subpoenas. And before filing the motion, the victim's rights attorney reaches out to the prosecutor to see if they want to join in the motion or file their own motion addressing the subpoena of the records that belong to Alex. So which type of remedy does this sound like an example? Is this a stop or is this a do-over? Absolutely, you got it in the chat. This is an example of a stop, right? Jerry's rights are at risk of being violated right now if their records are released. And the victim's rights attorney and possibly a prosecutor have gone in and said, don't do it. Don't release them. Don't violate the rights. You got to stop this before it happens. And there are a lot of different ways that attorneys can do this. Lots of different examples of stops and do-overs. And I've included a few just on the screen so we can take a look at what they might look like, because it's not always motions to quash subpoenas. We just use that one because it happens to be a pretty common moment where victims need an attorney, right? They want the assistance of an attorney to help. So there could be those motions to quash. There can be a motion for accommodations if a victim needs an accommodation, motions for restitution, motions to identify victims using initials or pseudonyms instead of by their true names, motions to prevent a pro se defendant, so a defendant who's representing themselves, from personally cross-examining a victim during trial, and to instead have some kind of standby counsel, some kind of attorney do that for them. There can be oppositions to defense motions trying to keep victims out of the courtroom. There can be motions to reconsider release conditions or to add new conditions of release. Motions seeking enforcement of victims' rights to the accompaniment of a support person. Motions for return of property when it's no longer needed as evidence if it isn't being returned to the victim. They might have to ask the court to get involved. Motions seeking enforcement of a victim's rights to notice of significant actions or proceedings if victims aren't receiving notice of these things. So there are a lot of different ways that victims can ask the court for that stop or that do-over, either on their own, through an attorney or the prosecutor, to try and get their rights secured.
Okay, so let's move on to a little bit more with Jerry and Alex. The case against the person who sexually assaulted Jerry ends in a conviction, and Jerry decides they want to provide a victim impact statement at the sentencing hearing. Unfortunately, a mishap in mailing leads to Jerry not receiving notice of the date of the sentencing hearing. Jerry provided a written victim impact statement that became part of the pre-sentence report, and when Jerry did not appear at sentencing, the prosecutor assumed that Jerry had simply changed their mind about wanting to give an oral statement as well. Jerry only learns of the sentencing hearing when they call Alex for an update. Jerry does not disagree with the sentence that was ordered, but Jerry is very upset that they were unable to be heard in person and provide an impact statement in person. Jerry doesn't know what to do and asks Alex for help. So what are some issues that we have here that are potentially at issue at this point in the case? What are some potential violations here? Because we know that Pennsylvania statute provides this, that victims have the right to submit a written and oral, it says and oral victim impact statement. And so what might Jerry want to do, right? We might want to ask first, what does Jerry want, right? The sentence went his way, but maybe went their way, but maybe they wanted something else. But there's actually a lot of things, right? So I'm not being notified, not to read the impact statement, right? All those things, prior comment not provided. So possibly we'd want a redo of the sentencing, right? With the opportunity to be heard. And not just because they want a different sentence, but because they actually want to be heard in person, maybe by the defendant, maybe by the court, or just to have the public hear them speak. And they probably and possibly want reform of the system, right? So thinking about compliance for future victims. Hey, the way you tried to notify me didn't work, and this could happen again. So maybe there needs to be something else going on. And maybe an apology from the court or the prosecutor, right? We kind of need to know. And then enforcement, right? I see resentencing in there. Redo, right? Yeah, maybe we can ask for a redo. We don't know what Pennsylvania law would allow regarding redoing the sentence, but it's possible. In Oregon, that is a remedy that's allowed to victims if in a plea hearing. You can't undo the plea, but you can have a resentencing. So potentially that would be an option. And so this is a thing too, where you may need a victim's rights attorney, or the prosecutor may be willing to do some of this stuff. So it really just depends. But I think these are all things you want to think about. And so referral to the victim's rights attorney. We've talked about it a lot, and we know that advocates have a lot of legal knowledge, and you guys are showing us that in this chat box, that you know what's going on. You know the system and how it works, but you have a lot of information to give victims, but there are things that a victim may need that you just cannot provide, both ethically and legally, right? Victims' rights attorneys, they have a role of being the victim attorney, not just an advocate that would provide them information, but actually have a different role. And they aid with crime victims' rights issues, help victim understand how to assert their right, to actually asserting those rights in courts. They can file legal motions. The key here is just don't shy away from those referrals, right? That when you see that a victim needs an attorney, to be making those referrals. And then here are some examples, and we've talked about some already, but what are some things that a victim rights attorney can do for a victim? File a motion for a victim who is not informed of the change at the time of sentencing hearing, so they were not able to give their victim impact statement, just like we in the prior example that we had. And the judge proceeded to sentencing without the victim present. We have an example where they filed an objection to defense attorneys overbroad and illegal subpoenas for child victims' personal records. So quashing those subpoenas, that happens a lot. If they can attend parole board hearings and advocate on behalf of the victim that the convicted person not be released, or be released if that's what the victim is desiring. File a motion on behalf of a victim of sexual assault who was ordered by the judge to turn over their DNA at defendant's request, right? So there's a lot of things that a victim's attorney can do. But, and this came up in chat at one point, that setting expectations so that victims understand. Victims need to know that even with a victim's rights attorney, they cannot force the prosecutor to drop a case. They cannot force the prosecution of a case generally if the police fail to investigate or the prosecutor doesn't want to go forward and bring specific charges. They don't have the veto power, right? So victims cannot come in and veto a plea negotiation. If the prosecutor is going to go forward with a plea no matter what, then that's what's going to happen. Victims do not have the right to dictate what the sentence will be. But again, they do have rights surrounding both plea and sentencing, right? To be heard, to have their opinions heard by the prosecutor and the court and the defendant if it's a victim impact statement. So there are things that victims' rights attorneys can do that are significant, but as always, we need to make sure we manage expectations and victims understand what they are able to do and accomplish through their rights and what they're not.
So there's a great question in the chat before it gets to the question on the screen. What about civil cases? Do these rights apply in civil cases? And I'm going to give you the most frustrating attorney answer you've ever heard, and it's going to be very unsatisfying. So I'm managing your expectation. The answer is, it depends. Sometimes, if a defendant is abusing a related civil case to try and do something that's prohibited in the criminal case, these rights could apply in civil cases. These rights are designed primarily to apply in criminal cases. That's what they were meant to do. So, but the answer about the civil is really, it depends. right? It's a lot harder than a nice satisfying answer. So I'm not going to give you a nice satisfying answer. You get the terrible attorney answer of maybe, right? Sometimes, possibly. So the related question, the question we've got on the screen though, is what about defendants' rights? Because we have spent the last almost hour and a half talking about victims' rights. And the question that often comes up is what about defendants' rights? Aren't we going to violate defendants' rights if we're giving victims all of these rights? And the answer to that is not really, no. Most of victims' rights don't conflict directly with the defendant's rights. They more kind of are adjacent to it. They kind of fly by. Many victims' rights are rights against the system. Their rights to have the system give them notice. Their rights to make sure that the system gives them an opportunity to be heard. Their rights against the system to make sure that it doesn't violate their other rights to privacy or privilege or things like that. So most of the time when victims' rights are at stake, they're things the defendant might be interested in, but they don't directly conflict with the defendant's rights. They kind of go side to side with them. But sometimes, you're right, sometimes a victim's right might butt up against a defendant's right. A defendant might be saying, well, I have a right to this information, and a victim might be saying, well, I have a right to keep you from this information, and those rights are going to conflict. And that's what courts are trained to do. Courts are designed and trained, and their entire function is to look at all the law and all the facts and decide in a case when rights are butting up against each other, how to ensure both people's rights to the greatest extent possible. They're going to look and see, does one person have a stronger right in this moment than the other person? And if so, maybe their right prevails, but while their right is prevailing, the other right doesn't go away. It still gets enforced to the greatest extent possible, while making sure that maybe the stronger right needs to come out ahead in this case. So this is what courts are designed to do. Analyze all this stuff. And that's what victims' rights assertion is really meant to do. It gets these issues before the courts so they can make that decision. Because without the decision, there's no opportunity for the victim's right to even be part of that mix at all, to determine whether it's doing one of those flybys or whether it happens to actually be butting up against another right. And when it comes to barriers to asserting and seeking enforcement of victims' rights, there are some, and some of these are really preventable and things that we can help with, right? Sometimes prosecutors or the courts aren't following the law closely or may not know the law, as well as often advocates know the law better than any other participant in the justice system because you're dealing with it every day with survivors. Victims might not know or understand their rights. They may not know how to get the court to get involved to protect their rights, right? There's a lot of gaps in the process without these referrals and without this information. Lawyers and judges aren't often familiar with it, and victims' rights issues aren't being litigated in the courts, in the criminal cases. We have a situation where there are rights on the books, just like defendants' rights were on the books for hundreds of years, but courts aren't picking them up and making those decisions that help keep them safe and help ensure that they're really robust. And we can do a lot about all of that by helping victims understand their rights, by facilitating choice and agency in the process, and when victims need help seeking enforcement of their rights, making sure that when prosecutors are in a position to be able to help, that they can do that, and making sure that when victims want their own attorney, they have access to somebody who has that legal knowledge and access to those legal tools to make that happen. Oops, I hit a couple. Whoa, I'm jumping all over the place. All right, very quickly, we are going to skip the first two polls. So we're going to skip over the true or false questions because we know already from your answers in the chat that you have got compliance and enforcement down pat. We know from your answers in the chat that you know how valuable rights really are. We want to take a moment just to see in your experience, if you go to menti.com. So we're going to ask you if you have another device or another screen, go over to menti.com and enter the code 36519267 and enter in some situations where a victim might want or need the assistance of their own attorney to help safeguard those rights. Because these examples come up all the time, and we highlighted a few in the hypothetical that we shared with you, But the situations where a victim might really want access to their own attorney is so much broader than what we already shared with you. So the code is 3651-9267, and I will put that in the chat. At menti.com. Obtaining restitution. Let's watch these as they come in, because these are all really good examples. Not being consulted before a plea, not being permitted to attend a plea or provide a victim impact statement or submit for restitution. When a victim has a grievance against the district attorney, right? Sometimes the prosecutor is not a safe or appropriate person for a victim to ask for help in helping seek enforcement of their rights. Attorneys not speaking with the victim, missing sentencing, not even knowing that a hearing was happening, right? That right to notice is really the gateway right. And if you don't even know that something is happening, you don't have the option or the opportunity to participate. Restitution, not being heard at pleas or notified at pleas, disagreeing with the district attorney, not allowing a victim to read their impact statement. Sometimes if custody of a minor might be involved. We haven't touched very much on juvenile cases. All of our examples have been in adult criminal court cases. Disagreements with a plea or restitution, confidential communications, victim impact statements. As I scroll through here, there are so many issues that victims could benefit from referrals to attorneys on when they reach a point where they really need help and they need the court to intervene and make sure that their rights are being respected. Not being allowed in the courtroom. So I'm going to switch back over and let you know that as we go through this, we are not asking you to go into it alone. We are not asking the attorneys that a victim might work with to go into it alone. NCBLI is here to provide support and assistance in those ways. And we've got two different resources on the screen. ncbli.org is our main website, and that's where you can go to request technical assistance, so more information about a specific right. And there are a number of resources available on that website as well, free downloadable resources, videos, lots of different things. And then NAVRA.org, the National Alliance of Victims' Rights Attorneys and Advocate, is our membership organization, which offers additional trainings and other downloadable resources to members as well. Because one of the things that we're working for is expanding this community. We know it can sometimes be hard to find a victims' rights attorney who's able to assist a survivor. So one of the things that we're doing is helping to train up attorneys, because any attorney can do this work. It's not something special or overly complicated. Any attorney can do it. And attorneys are often very hesitant to go into new areas of law without some support and additional information. So thank you so much for joining us today. We know we've got a couple more webinars coming up as well, but it was great. We appreciate all of your knowledge that you were able to share with us using the chat. And thank you for interacting and being here with us. We look forward to seeing how enforcement goes in Pennsylvania now that standing is explicit and hopefully easier for folks to use.
And I just want to jump in real quick. We have had so much action in the chat with so many good questions. A couple of things, Becca and I cannot give legal advice right now. So answering a lot of those questions, they're fact specific, so it's really hard. We can't do that. Some of the questions, like the one that just came in about, is it possible to have a sentencing reconsidered in Pennsylvania? That is a great question to send to our TA request at www.ncbli.org and fill out a TA request with that question, because that requires legal analysis. We would not be able to answer that right now. We're not experts in your law. We'd have to do some research and stuff. So I apologize for not being able to answer all these questions. I tried to do some, but you guys are great in asking those questions and really thinking, and I can tell you do a lot of great work for victims. Thank you.